This bill, now full disclosure, by the way, I should say at the outset, I'm litigating the Exeter case that Representative Cordelli spoke about. So I was obviously happy when he told me he wanted to introduce this legislation, but the topic that's being addressed by this bill is much, much broader than anything that was raised in my case, including gender or even free speech. The problem that this bill addresses is that everyone agrees, all courts have held in New Hampshire under our state constitution, if your rights are being violated on an ongoing basis or there's a threatened future violation of your rights, everyone agrees you have a right to relief under our state constitution and our state courts, even if you just ignore the federal constitution. But if there's a completed violation of your rights in the past, no New Hampshire court has ever held that you have a right to any remedy whatsoever, even a nominal damages award for that violation. If it's a retrospective violation, you have no right to any retrospective remedy, not even nominal damages, not even declaratory damages. The court can't even say you win and you get nothing, no right to relief. So when Representative Cordelli told me he wanted to introduce this bill to address this, I was excited about it. But I will say that I definitely don't see this bill as any kind of rebuke to Judge Schulman's decision, the trial court judge in this case. I think he's a great jurist, actually. The opinion was largely favorable. And Judge Schulman was right to say no New Hampshire court has ever held that if you bring a New Hampshire constitutional suit, you have a right to retrospective relief. Now, that's all rights. That's not just free speech. That's free speech, right to bear arms, right to freedom of the press, any right. If it's in the past, you're not going to get relief unless you go into federal court under the federal constitution instead of going into our state courts. And this is something that this legislature can fix. If we want people in New Hampshire to be able to rely on our state courts, and we want New Hampshire to be independent, and we don't want Granite Staters to have to rely on and essentially be dictated to by what federal courts happen to say at that moment. So I actually have a case before the state Supreme Court right now where I have like a 50-page brief that basically is arguing the New Hampshire Constitution itself entitles you to retrospective relief if you look at the text or the history of the Constitution. But even if I win that, it is a good idea for the general court to have a statute addressing this, just like under federal constitutional law, you can bring a 14th Amendment suit, or if you don't bring a 14th Amendment suit, you can bring a Section 1983 suit under a statute that Congress passed in 1871. And they basically passed that to backstop our federal constitutional rights and make sure you have a remedy in court. And that is what the legislature would be doing by passing this law. So regardless of what you may think about what the framers of our state constitution intended, I would say if you just think about it logically and from a standpoint of basic fairness, it really just does not make sense. It's kind of a fluke to say you have a right to relief if there's a threatened future or an ongoing violation, but if it happened in the past, you have no right to relief. A right is a right. You should be entitled to some sort of remedy. And I would love to take any questions, but one thing I'll say is really any possible political objection I could think of to this bill, whether that's what about frivolous suits we have to deal with? How do we deal with the various official immunity claims? My answer to all those is going to be pretty simple, which is our courts already know exactly how to deal with all those questions under ongoing and prospective claims and under federal constitutional claims. They have an extensive body of case law that will analyze any one of those issues that I just raised. So just the last thing I'll note here is that New Hampshire has the second oldest continuously existing constitution in the Western world after Massachusetts. Our constitution goes back to 1784. And when our constitution was being passed, Granite Staters 3 times rejected in popular votes the constitution that was proposed to them because it didn't provide the people enough rights against the government. And the framers kept adding more and more rights until they had something that the people of New Hampshire were satisfied with. Our Constitution takes as its model John Adams' original Massachusetts Constitution. But if you compare the two, if you look at our Constitution and you look at Massachusetts's, you'll find Massachusetts's just sounds relatively weak. It's got the same rights, but our framers put a lot more kind of fanatical emphasis on those rights because they wanted to emphasize the government would be restrained the people have strong rights, and we want to assure you, Granite Staters, of that so that you'll approve this Constitution. So I would say it especially doesn't make any sense in New Hampshire that we have this kind of historical fluke and oversight where if a violation is in the past, you have no right to relief. So I'd be happy to take any questions about anything.
Representative McFarland.
Thank you, Mr. Chairman. I'll just reiterate my prior question with a little bit more specificity. So, if I understand you correctly, you're asserting in section 2 in rows 12 to 14 here, to the extent that you agree with the language, you're asserting that you already had this remedy under the Constitution, and that this is also now being granted in this statute, and you already had this remedy in common law. And if I'm right about that, could you also please clarify how this would affect the ability to petition for redress of grievances to the General Court?
Representative, I think you have a pretty comprehensive understanding of the issues. I would just add one thing to what you said. Yes, that is part of why Section 2 is worded this way, but also our constitutional law in New Hampshire has a weird fluke, separate from what I've just talked about, that is not found in other states, where when you bring an Article 14 claim, our state Supreme Court actually, I don't think anyone else does this in the country. Some kinds of constitutional claims, when the court is deciding whether you have relief under the state constitution, they actually will look to state statutes to decide whether you have constitutional relief. So this isn't just kind of a way to say, we disclaim the idea you don't have a constitutional remedy. It actually also could affect the outcome of cases. The last example of this most recently was Cater, Khater. That was in 2010. And basically what happens is the court says, if we will grant you a constitutional remedy under Article 14 in this quasi-equitable way, if the general court is not granted you statutory remedy. And the second part of your question, I don't see the only way in which it would, there could be a case that addressed the right to petition the general court is, the only thing I can think of, I'm just thinking on my feet here and spitballing. If, let's say your right to petition was denied for a long time, and then the general court eventually granted your right to petition, and so then maybe your prospective claim is moot, but you say, hey, but they unconstitutionally denied my right to petition for a year. So you don't have any prospective claim anymore, but let's say you say, I still want nominal damages, or at least declare that what they did was unconstitutional. Right now, that retrospective claim you don't have, because our courts would say retrospective constitutional rights claims, no remedy. But now you would have one under this bill.
Thank you.
Any other questions? Yeah. Representative Tur?
Yeah, thanks. Thanks for taking the question. I'm wondering, and I do not know this area of the law particularly well, is the difference between the future or current situation of having your rights violated versus what's being discussed in this bill, the idea that primarily that would be, and maybe I'm misusing the term, sort of injunctive relief, which says the court's going to stop your rights from being violated, whereas this seems to be awarding damages in a very different circumstance.
That is right, except that our courts have been very clear that they've never, as I think Judge Shulman accurately said in his opinion, there has never been any case in New Hampshire that says you have any retrospective right to relief. So this bill kind of pointedly doesn't even really take up directly the monetary damages question, and basically just says, look, you've got some sort of right to relief. Could be nominal, could be declaratory, could be some other equitable relief. But you're right, you have prospective injunctive relief if your constitutional rights are going to be violated in the future. But if they've been violated in the past, right now, not only can you not get monetary damages, you can't get anything under the state constitution. I should address the quote Representative Cordelli opened with from Judge Shulman's opinion. The reason that Judge Shulman spoke about bodily injury and things like that is you could bring a tort claim against a subdivision or against the state. So if a police officer beats you up illegally, let's say, you might bring a tort claim for bodily injury, but you couldn't say that police officer violated my state constitutional rights under A, B, or C provision of our state constitution. You would just have to rely on tort law, or you could, under the federal constitution, go into federal court, but people really should be able to remedy these claims in our state courts. Thank you.
Any other questions? Representative Manos?
Thank you, Mr. Chair, and thank you for taking my question. I'm really not clear on what specific remedy it is that you're seeking by way of this statute. That I get the nominal damages, but isn't a judge going to say, whatever the situation is, it's aside from Exeter, somebody's state constitutional rights were violated? The judge has to say that. Otherwise, there can't be any conclusion to the case. There can't be a judgment. So just the acknowledgement that somebody's rights were violated is, in fact, the remedy.
You raise a really good point, actually. And in old nominal damages cases from like the early 19th century, Justice Story on the U.S. Supreme Court said the idea that you can say someone's legal rights were violated, but they have no remedy whatsoever, not even nominal damages, that doesn't even make sense, he argued. You're just, it's incoherent, because if there is no remedy, we would typically say that really isn't a legal right. Maybe the government did something immoral, but they didn't violate your legal rights if you have no remedy. In this case, I mean, this is kind of an illustration of your question. The judge said, it seems like under the facts here that your rights were violated, that the school lied, etc. But regardless of any of that, you lose because it's a retrospective claim. So we don't even have the right really to declaratory judgment. We don't have the right to have the court say you win, as long as it's a retrospective claim. The three kinds of remedies that are mentioned in here are, as you mentioned, nominal damages, declaratory relief. And one thing I'll comment on that I am inferring you're aware of based on your question is with respect to the other equitable relief clause. Already, actually, our state Supreme Courts under just general court statutes are courts of equity. So that other equitable relief clause in some ways is just kind of re-articulating the equitable jurisdiction our state superior courts already have. So you could interpret this bill as kind of just saying, when the minimal possible relief that could remedy a retrospective violation, that's the relief you have.
Yeah, follow up.
Thank you. But there would have been a judgment entered in this case, correct? And it would have said A violated B's rights. And isn't the person or the entity that violated that person's rights put on notice not to repeat the behavior? And of course, if they do, then you can get declaratory relief and injunctive relief, et cetera, for prospective behavior or future behavior.
Well, they did win. The end of the opinion says that they won, and the statements from the school, and in my case, for example, have been, we disagree with the judge saying our clients all lied, but we're glad we won, and they are right. They did win. And I would say, setting aside the facts of my case, in my appeal is just on the question presented of, does the New Hampshire Constitution afford retrospective relief for completed violations? We're not talking about gender or what the free speech test is or any of that stuff, because the judge really kind of decided all that stuff in our favor. So regardless of what you think about the judge's opinion in my case, under any future case, in the absence of something like this and or Supreme Court decision in my favor, court's going to say anyone whose state constitutional rights were violated, you have no retrospective relief.
Could I just ask one?
Yes, go ahead.
Would you be willing to provide us, and redacting if there are minors involved in the case, would you be willing to provide us with a copy of the court's opinion?
Absolutely. I'd be willing to provide you any documents, and they are already all redacted, so that'd be very easy. Thank you, Representative.
Any other questions? Seeing none, thank you.
Thank you.